There are some hidden risks in owning property with your adult children. And many people don't think through this as they look for ways that they think will help them beat the system and transfer assets to their children outside of the probate process. Here's what you need to know about that. Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust in Lawrenceville, Georgia. And we do get people who call or come see us from time to time, and they want to talk about, I just want to put my adult child or my adult children on all of my financial accounts and on the deed to my house so that when I pass away, it's not going to have to go through the probate court process and those assets will just be theirs and readily available. Or they say, I want them to be able to do this so that if I'm incapacitated, they can manage everything. And I understand where they're coming from, right? They're trying to think about ways to make sure that if they can't pay their bills, the kids who they trust can do that. Or if they pass away, the kids just already own it. And so they don't have to spend time settling the estate and going through a probate court process. And if it was just that simple and straightforward, that might be a good idea. But the reality is it's not. And here's why. Here's the hidden risk. So, first off, let's suppose you add your adult child or your adult children to the deed of your house. Okay. And you're doing that so that it's going to avoid probate. Well, let's suppose that adult child or one of them goes off and they get into a bad wreck. A lot of people are maimed and injured and killed. There's a lot of damages and they've got some insurance, but they don't have that much insurance. Now their assets are at risk of loss to their creditors or judgment holders, and their assets include your house. Because, see, once you put them on the deed, they're a co owner, they're a joint owner, and you might wind up losing your house or having to pay to defend and keep your house because your adult child got in a wreck and caused harm to somebody else. Likewise, if they ran up a lot of credit card debt or had a failed business and something happened and people, creditors, are coming after them, again, your house might be at risk to satisfy their creditors and their judgment holders. Let's suppose that nothing happened like that. Everybody was getting along just well, no problems, no risk, but you've got these adult children on the deed. You then want to go sell the house because you want to move somewhere else. Well, you've got to get the permission from all of those other co-owners. And if one of them has died or become incapacitated, that puts a big monkey wrench into this plan because now we're going to have some legal representative for them in many cases be able to sign for them and work things out. It can be a real mess. And we talked through this example about the house, but it really applies to other things such as money in the bank, your bank accounts, your credit union accounts, investment accounts as well. If you put the kids on as a joint owner, well, again, it's their money. It can be attacked. It can be at risk for their creditors or judgment holders. Or if they just decide, I really need a vacation, I'm going to take some of this money out and go to Vegas and see some shows and gamble and swim in the pools and all of that, drink one of those umbrella drinks, and they're doing that with your money, well, it's their money too. And it's not theft because you made them an owner. So there can be some real bad consequences of simply owning the property jointly with your adult child or your adult children. There's also a negative consequence that comes to them when they inherit certain types of assets via this way of making them joint owners during your lifetime. And this really plays out when we talk about real estate. So let's take your house, for example. Let's say you've got an adult son, John. If you add John to the deed of the house with you, you make it as joint tenants with right of survivorship so that when you pass away, it all is automatically his. From a legal ownership perspective, yeah, the transfer of the property happens just like that. As soon as you pass away, he owns it all, provided he survived you. But now he's in probably a far worse tax situation than he would be if he inherited it at your death via a will or a trust or a transfer on death deed. Because you see what happens once you put John on the property deed with you, you've made a gift, a completed gift. And his cost basis in the house is your cost basis. So when he goes to sell it from a capital gains tax perspective, his cost basis is whatever you bought it at. And so if you bought it down here and he's selling it here, he's got capital gains exposure on all of that. But if he inherits it through a transfer on death deed or through a will or through a revocable trust, then his cost basis in the property won't be where you bought it. Instead, his cost basis is going to be the fair market value of the property on the day you died. So instead of potentially a capital gains exposure from your purchase price up to his sale price, his capital gains exposure might just be from the fair market value when you died to the purchase price. And if there is a difference, that's probably going to be small. If he holds the property for a long time, it's going to appreciate more, but at least he's only got capital gains exposure from the date of your death to when he sells it, as opposed to when you purchased it. So, for those reasons, the risk that it poses to you by making them a joint owner, and then two, the negative tax treatment that it gives your kids by making completed gifts to them, for those reasons, we don't recommend that you own property jointly with your adult children. That's really not a good estate plan. You can do better, and you can still make things easy. So, we can put a plan in place. You can use a revocable trust where things can be settled privately and out of court, and maybe even provide for some asset protection for your children and grandchildren via that types of trust. You can also transfer things to them via a pay on death or transfer on death beneficiary designation. And you can even keep the house out of probate by either using a revocable trust or Georgia's relatively new transfer on death deed, the TOD deed, and have that pass. What's the best way for you? I can't tell you in this video. I can't hear your situation. I don't know what your goals are, but you can come meet with one of our planning attorneys and get some customized recommendations for your situation to help you accomplish your goals. Now, for more information on estate planning in Georgia, visit us at peachstatewills.com. At the top menu bar, click free info, click estate planning resources, and download our free guide to estate planning. Or if you're ready to get started and meet with a experienced estate planning attorney, call us, get our questionnaire, fill that out, and schedule your Georgia Family Protection Strategy session where you can meet with one of our experienced attorneys, get some detailed guidance and insight based on your situation and your goals, and put a plan in place to protect you and your family. Let us know how we can help you. Thanks.